So we're just going to hear from our last speaker via Zoom, George Newhouse, who's a leading Australian human rights lawyer and an adjunct professor of law at UTS and Macquarie University, and the CEO of the National Justice Project. A tireless advocate for social justice and law reform, he's best known for fighting for marginalised communities, including refugees, detainees, people with disabilities, and First Nations peoples. And so do we have George up on the screen? Thanks, George. And just letting everyone know that we will be going slightly over the projected end time of 4 p.m, and hopefully we'll have some time for questions as well. Thank you.
Well, I'll try and keep it short. Oh, I am getting... You all hear me?
Yeah.
Okay. First of all, I also want to acknowledge that I'm coming to you from our Sydney office, which is on the lands of the Gadigal people of the Eora Nation. Some of the cases in this presentation may cause distress. I'm not planning on going into them in detail, but we're talking about the coronial jurisdiction, and some of them can be distressing. And they also include the images of Aboriginal and Torres Strait Islander people who are now deceased. For those of you that don't know the National Justice Project, we work to create systemic change and amplify the voices of communities that are harmed by government inaction and discrimination. And one of the ways we do this is through strategic litigation, and in particular through inquests. And we see inquests through a very different human rights lens to the two previous speakers. Our experience is really from the perspective of the families and the deceased. Now, the coronial jurisdiction is not just one of the oldest jurisdictions in Australia, but one of the oldest in the English legal system. It's a strange artifact to be using to drive change, but I hope that this presentation will explain how the court became such a powerful institution in the context of human rights, and why the court is currently under attack by the Chief Minister of the Northern Territory, and some of the problems with more conservative coroners' courts. And I'm not talking about the Victorians in particular. Coroner McGregor is an exemplar and a light amongst the coroners in our nation. You might ask why the National Justice Project uses inquests to drive change. And I think the answer is because coroners' recommendations can have profound social impact. And that potential was recognised by the Royal Commission into Aboriginal Deaths in Custody. In the early 1990s, after the Royal Commission, states and territories began to respond to the recommendations by implementing sweeping coronial reforms. Now, I'm not suggesting that all the Ricky Dick recommendations were implemented by governments, because they weren't. And a lot of people have died because they weren't. But the recommendations about post-death investigators being empowered, not just to determine the cause and manner of death, but also to investigate systemic issues and to make prevention-focused recommendations, were generally implemented. Now, on the screen, you can see Recommendation 13 from the Royal Commission, that a coroner inquiry into the death in custody be required to make findings as to the matters which the coroner is required to investigate, and to make such recommendations as are deemed appropriate with a view to preventing further custodial deaths. The coroner should be empowered further to make such recommendations on other matters as he or she deems appropriate. These were quite profound recommendations at the time. The powers that Coroner McGregor exercised in Veronica Nelson and XY were not available to coroners before 1990. I think that Coroner Alastair Hope from Western Australia summarised it well. He said the Royal Commission provides a timeless reminder that every avoidable Indigenous death calls upon us to identify the underlying causes, consider Indigenous disadvantage, uncover the truth about the death, and resolve upon practical steps to prevent others. Sadly, some of the coroners that followed Coroner Hope in Western Australia have not always lived up to that standard. But like Coroner McGregor in XY and Veronica Nelson, Coroner Elizabeth Armitage did put those Royal Commission recommendations into practice. She recently delivered findings that the shooting death of 19-year-old Kumanjai Walker was avoidable, and that the then Constable Zachary Rolfe harboured racist attitudes that could have contributed to his decision to shoot Kumanjai Walker. The inquest also found that Rolfe had used unnecessary force on prior occasions and noted normalised racism in the Alice Springs police station, though she stopped short of finding systemic racism across the NT police force due to insufficient evidence. The coroner made 32 formal recommendations aimed at police reform, addressing racism, including strengthening the NT Police's anti-racism strategy, enhancing community support and engagement, and enhancing police accountability through improved complaint processes. So without detracting from the wonderful work of those present today, I just want to cite one example of how inquests can be impactful. The National Justice Project represented Leanne Little, who was a witness at the Kumanjai Walker inquest. When she gave her evidence, Leanne was a former police officer, and she directly contradicted the evidence given by the NT Police Assistant Commissioner to the coroner. The Assistant Commissioner claimed that there was no systemic racism in the NT Police Force. Leanne's controversial evidence led to an apology from the NT Police Commissioner to First Nations people at the Gama Festival in that year, and the introduction of an anti-racism policy for the NT Police, which is now being prepared and implemented by Leanne Little. And I really believe that that came from Leanne's evidence at the Kumanjai Walker inquest. However, not all coronial findings are well received. The Northern Territory Chief Minister does not like the recommendations of the coroner. She stated on FM radio that her government is considering changes to the Coroner's Act as a result of the Walker inquest, which would be astounding, taking us back to pre-1990 legal status of coroners. And for those that don't see systemic prejudice, I'm quite convinced that the Chief Minister of the Northern Territory will not accept that there is systemic racism in the NT Police Force. Like a lot of people, I'm sure that she sees prejudice as an individual issue and the result of a few bad eggs. But coronial inquests have provide an opportunity to look deeper into systemic issues. And I thought you might like to see one example of systemic discrimination that Leanne Little provided to the Coroner's Conference in Alice Springs last year. Now, I don't know whether you can see those details clearly, but what you can see in the top, on the top graph, is the rise of Aboriginal prisoners since 1996, which was the election of the Howard government. So changes in the law and in policing and policy since 1996 has seen an exponential growth in Aboriginal prisoners. Now, the orange line down below are non-Indigenous prisoners, and you can see there that they're virtually unchanged. Virtually unchanged. And I think it demonstrates how the introduction, and the blue arrows are increasingly difficult legislation that criminalises Aboriginal communities. And you can see at every point the number of Aboriginal prisoners increases. Now, this chart does not include the current legislative changes that the new Country Liberal Party has introduced. And I think that the gap between Indigenous and non-Indigenous prisoners is going to grow even greater. Now, I do want to quickly deal with the need for reform. I think Victoria and now New South Wales do have exemplary coronial systems, but not all coronial jurisdictions are as perfect or as effective as what we've heard today or seen recently in the NT. The majority also do not have to apply human rights considerations. You're fortunate in Victoria to actually have a Human Rights Act. We don't have one in New South Wales, neither do most states and territories. And it's our view that culturally safe inquests should be mandated and that they should not have to rely on the goodwill of individual judicial officers. On the screen, you can read some feedback from an advocates group who made a submission to a review of the ACT Coroner's Court. Now, whilst they acknowledge that there are some people that have positive experiences, most felt re-traumatised, stigmatised, disadvantaged, unheard, dismissed and sidelined throughout the process. And I think that's not an uncommon phenomenon in some states and territories, not present company accepted. And we've been calling for that national standards to be introduced to ensure that people's journey through the coroner's court is not traumatic, is not stigmatized, and that people are heard. And I've been involved in inquests into the deaths of dozens, I think nearly 100 people, because that includes this Civ 221 boat disaster. And what families and communities tell me is what they want from the court is up on the screen, but it's really respect, a voice, to hear the truth come out, to see real change that comes from the inquest so that no one has to experience what that family has, and for there to be accountability and finally closure. Sadly, they rarely get what they call justice, but that's, but that's not always because of the manner in which the coroners conducted the inquest or in their very miserable findings or recommendations, but because of the limits of our colonial legal system. You know, there are limits to what a coroner can do, and most people don't believe that they receive a form of justice from that process. When I say most people where there's a death in custody or a death where there's allegations of systemic discrimination. And I think one way to meet the needs of First Nations families in particular is for the Commonwealth to establish a First Nations-led investigative organisation to work with state and territory police and coroners around our nation on post-death investigations. The National Justice Project is currently acting for the family of Kumanjai White, who died in a Coles supermarket in Alice Springs at the hands of police, and his family are complaining publicly that the relationship between First Nations people and the NT police is completely broken, and they don't trust police investigating police, and they want an independent investigation. And you can see on the screen that the response to that is no. But to add insult to injury too, they're confused about the role of the police, because not only are the police investigating the conduct of the officers on the day from a criminal perspective, but they're also acting as investigators for the coroner. And there's a real confusion about, am I talking to a police officer in relation to a coronial investigation or a criminal investigation or some other disciplinary investigation? And for First Nations people, it is time for an independent organisation who can work with coroners, who can work with police forces around the country, but to provide a trusted body for First Nations people. Now, I think we've gone over time. I did have some examples of particular problems with particular jurisdictions and some other cases, but I think given that we've run over time, I might end my my piece there, and I'm very happy to answer questions if there are any.